This is Professor Wes Porter. Today we're talking about the Federal Rules of Evidence, and specifically Article 4, character evidence. I want to take on today the idea of issue spotting character evidence out of a fact pattern. We find that students can recite parts of the rules, understand the exceptions of the rule, be able to talk about the rule, but the idea of isolating character evidence, spotting the issue of character evidence, knowing what parts of character evidence at issue becomes the challenge for some students. We're going to focus on two questions that you could be asking yourself when looking at an essay to see whether character evidence is at issue. When and who? Let's focus first on when. Think of every case. Every case has a timeline, essentially a body of time when the events took place. Things that are inside sort of the box of the case. And you can imagine that timeline forming a box. Well, you'll see dates and events described in a fact pattern, just like you will in a case file. And occasionally, you'll see things that are well within this timeline. But you'll also see items that are outside of the timeline. All of a sudden, we were talking about something in June and July. That's when the facts of this case took place. But they'll revert back and talk about something years earlier, months earlier. That's outside of the box of that case. That's outside of the timeline of that case. That's a number one clue that you're going to be talking about character evidence, because we have a story of the case, we have a timeline, but now, for some reason, we've introduced evidence about someone in the case, but it's outside of that timeline, outside of that box, outside of the story of the case. So that's number one. Look at when the evidence comes from. The second question is who. And character evidence is very, very narrow when it talks about who. And I want you to think about character evidence under Article 4 as relating to the characters in the story of the case. Not relating to everyone that has anything to do with the case, but just the characters. Criminal cases, this is primarily the criminal defendant and the victim of the offense, if there is one. In a civil case, the characters that at play are really reduced to plaintiffs and defendants. Those are the characters in the story. There are some exceptions, but really we're talking about criminal defendants, victims, and occasionally plaintiffs in a civil case. That's the who we're talking about. And the biggest thing that you want to distinguish with who it is not is it is not merely a witness. If it is merely a witness that we're talking about as it relates to character evidence, if it is merely someone who saw two cars crack into each other at an intersection or saw a crime take place, they're just a witness. They're not going to be a character in the story of the case. Instead, they're someone that's going to feed in details and add color to the story. So when we talk about the who, focus on, is it a criminal defendant, victim in a criminal case, or parties in a civil case? If it has to do with just someone who's a mere witness or outside of those characters, you're talking about impeachment. You're going to Article 6, and you're focusing down on only one character trait that matters. That's the character for untruthfulness, the witness's credibility. Lastly, let's talk about the difficulty of recognizing the form of acceptable character evidence. We know that 405A says that when introduced at trial, character evidence must be in these two forms, opinion and reputation. I'm here to tell you that opinion and reputations are the most unpersuasive and unimaginative forms of evidence that we have. Mr. Witness, do you have an opinion about the defendant's character trait for honesty? I do. Assuming proper foundation, what is your opinion of the criminal defendant reputation for honesty? I think he's honest. Not very persuasive evidence. The best type of evidence is the most difficult to recognize in case files and in fact patterns, and that is specific acts, story time. When instead of just saying or concluding that someone's honest or dishonest, we tell a story from the past. We tell a story from outside of the timeline, outside of the box, about one of the characters in the play. And we tell that story, that specific act story, so the jury can conclude, oh, I see the defendant is honest. Oh, I see the victim is dishonest. So be careful and recognize, if you answer these questions, when did this thing occur? Is it something that's in the box, or what we call part of telling the story, or inextricably intertwined with the evidence? Or is it outside the box? Is it more likely to be character evidence because we're drawing something from outside of the story of this case? Who does it apply to? Does it apply to the criminal defendant, victim in a criminal case, occasionally parties in a civil case? And lastly, what form is the evidence coming in? It's a big red flag when they say Mr. Witness came in and offers an opinion about someone or offers their reputation in the community for a particular pertinent character trait. But look out for the story time. Look out for when they're telling stories from the past that relate to characters in the play. Hope that helps you spot issues in character evidence under Article 4.